cover all disputes. So one of the ways of languaging all disputes is all disputes arising out of, from, or in connection with this agreement. This is a standard one in many of the contracts. Okay, arising out of, from, or in connection with the agreement, including its validity. If you don't do this, then there is a lot of risk that parties will say, oh, this is not from this agreement, this is like connected in a different way. Okay, so you want to write this out of, from, or in connection with, including its validity. So can you write this, just all disputes, you're drafting the first part, okay, imagine, and you can keep your notepad or whatever you're writing on, or type on your computer, all disputes arising from, in connection with, okay, or out of this agreement, including its validity. Okay, mention the location of arbitration proceedings, and this is the legal location, it's called seat. Okay, so in your country you can mention the city, the town, wherever. Okay, so mention the location, legal location. Okay, remember this, that the jurisdiction of the courts in that state will be applicable then if you choose a particular seat. The tribunal may give the power to the tribunal to conduct proceedings elsewhere, including virtually, so that there is no inconvenience, practical inconvenience to parties. Give the power to the tribunal to conduct proceedings in other locations, include with the agreement of the parties, including virtually. Okay, make arbitration mandatory, so make sure that it's all disputes shall be. Okay, shall be, not may. If you are specifying a period for negotiation or amicable settlement, never say that upon failure of this then it will go to arbitration. Never say without undue, upon failure of this, or if there's undue delay it will go to arbitration. No, keep a fixed cap, 30 days, 15 days, 7 days. Okay, 30 days they will try to mediate. Okay, if it doesn't happen, it shall be resolved by mandatory arbitration. What are the logistics? Now here people ask me, one person asked me, what are the logistics part? You have to say the size of the arbitral plan. See, if you don't do this, it may not fail. It will not fail, because every country has a law which says that if you don't mention that what is the size of the arbitral tribunal, it'll be, say, one arbitrator. Okay, arbitral institutions, if you are appointing something like an ICC, they will say that if you don't specify number of arbitrators, we will have, let's say, 1 or 3. Okay, but to make this more certain, clear, you want to specify the size. It's very important in arbitration to control costs. The bigger the arbitration, the panel, the bigger your costs. So you have 1 and 3 is the common practice. Okay, it has to be an odd number because you don't want a tie, right? So 3 is going to be more expensive because you're paying 3 arbitrators. So 1 is what parties prefer the most. Okay, if you're cost conscious. So mention the size of the panel, 1 sole arbitrator or 3 arbitrators. Then mention the qualification. Okay, should they have some experience in the engineering sector, in the software space, in the technology space? Okay, what should their qualification be? Do you want a qualification, or just you want to keep it general, but mention something? Okay, otherwise you will not get a relevant arbitrator. There's a risk. Okay, specify the fees. Okay, in the Indian Act it will refer to the schedule, but it can be disregarded if High Court, Supreme Court appoints an arbitrator. Then you must specify the mechanism, who will bear the cost of arbitration. So what is the best case scenario? Usually both parties to bear their own legal costs, and sharing arbitrators' costs equally is the most common, is one of the common practices. Other option can be that losing party bears the costs, okay, of arbitration. Lawyers' costs, maybe each party can bear their own, but provide a mechanism.